In response to our recent video about having an anonymous LLC in a state that doesn't allow anonymous filings, we got this comment, anything can be subpoenaed. So what I'm going to say in response to that is that's right and it's wrong. So we always tell our clients at a certain point in time, there will come a point where someone will be able to find out who is behind all of these layers if you let it get that far. So yes, if you go all the way through litigation, if you are unfortunate enough to have a judgment put against you and you're put under oath, at least here in the state of Florida, yes, they will then have a right to ask about your corporate entities, who owns what and what assets you have. Well, the correct legal answer at that time will be, I own a trust that owns an LLC, that owns an LLC, that owns a trust, that owns an LLC. And yeah, and maybe that trust is owned by another trust. So we always call it layers of the onion, putting firewalls around different assets. So the comment is technically true in some ways, but a little bit misleading. So, and we never lie to anybody. We never tell anybody this is, there's 100% guarantee from anything. But what we really focus on, and this, I think what's most important for most people to understand, is that really the anonymity comes in at the outset. So if you are facing liability and a litigation attorney, a plaintiff's attorney is looking to bring suit, they're going to run an asset search. And at that time, they either have to roll the dice, risk their entire payment, because we all know they only get paid when they receive money on a contingency or a percentage basis. So if they roll the dice on someone that shows zero assets, there has to be a real reason to do that. And they may think that you have something, they may think that there's something out there, but that's a lot different than running public records and seeing 50 assets that come in the person's name. Guess who's a better target? And you can easily answer that question. So to that point, yes, actually, absolutely anything can be subpoenaed. Now, it's not always relevant to a case. I've litigated for the majority of my 23 years, and in Florida, at least, when they try to get personal financial information during the pendency of a case, that's a strict no-no. It's prohibited. There's an opponent in a piece of litigation in the state of Florida has absolutely no right to look into, to inquire, to discovery, to subpoena personal confidential financial records, and they absolutely don't have a right to find out whether or not the person has the ability to pay a judgment they don't yet have. So yes, while if you are subject to a valid court order or subpoena, you may have to respond to that at a certain point. If it's done correctly, the answer still shouldn't hurt you. And it's really a question of making sure you do your best to look as non-appetizing as possible to the public if they are to make a claim against you.